O'Brien of the disability law firm of O'Brien and Feiler. I put this video together to share with claimants who might have a disability hearing in front of them. The title of this video is What to Expect at Your Disability Hearing, and the purpose of it is to give individuals that have waited a couple of years to appear in front of a judge a little bit of insight about what they might see and experience during their disability hearing. I would caution you, however, to say that every disability hearing and every disability judge is somewhat different, so this is not a one-size-fits-all suggestion, but rather general guidance on what somebody might be able to expect as they embark upon their disability hearing. The topics that I'm going to cover very briefly in this presentation are straightforward. I'm going to talk about planning ahead, what needs to be done in advance of the hearing. I'm going to talk about good information to have at your fingertips when appearing at a hearing. I'm going to talk about the who's going to attend the hearing. It's a surprisingly small number of people. I'm also going to provide a typical top-down map of a hearing room so that claimants can see where everybody sits and who all is going to be participating. We're going to talk about what's going to happen during the hearing as well as associated time frames. We're also going to talk about tough topics that claimants would do well to prepare for if any of them concern them. And finally, I'm going to provide some good general advice for claimants as they get themselves ready to appear in front of an administrative law judge for their disability hearing. The first step is planning ahead. You've received your notice of hearing, which includes your hearing date as well as your hearing location. Your hearing may well be located in a federal courthouse not too far from your home, or it may be located in a nondescript office building where the Office of Hearing Operations has chosen to rent space. Regardless, I highly recommend that you plug the address into a GPS or into Google Maps or any service that you choose to map the hearing office from your home, not only for mileage, but for traffic as well, in particular traffic at the time of day before which your hearing will be held. Many hearing offices are located in metropolitan areas that have severe traffic issues around them. It is wise to be prepared. Additionally, plan on arriving to the hearing office at least 30 minutes beforehand. This additional 30 minutes will give you the opportunity to speak with your attorney, will give you the opportunity to review your case file, and will give you the opportunity perhaps to calm your nerves before going in front of the judge. Additionally, sometimes judges run ahead of schedule, and if they're able to see you early and you're available, it could result in preventing undue delays. It's important to note that before you enter a building for your disability hearing, you will be scanned by security personnel. Now, the security scans are different at the office buildings versus the federal courthouses, but generally speaking, I highly recommend that folks check their purses and pockets for items that could cause problems before they ever enter the building. So if you carry a pocket knife or pepper spray or other weapons, it's important to leave them at home. Check your bags for these because they could result in getting caught up at a security checkpoint. Additionally, it's important to note that if your hearing is being held in a federal courthouse, federal courthouses do not allow devices with cameras in them. This includes laptops, cell phones, and tablets. They will take your device from you at the front door, give you a check tag, and then they'll give it back to you after you check out. I recommend folks either leave those devices at home or in their car just to save an additional step. Finally, it's important to travel with your ID. Ensure that you have your identification ready for examination by the security officers. I also recommend carrying your notice of hearing letter because that can often answer questions for them as well, as far as directing you where to go within the building and ensuring that you're in the right building, right place at the right time. Finally, it's important to note that once you pass security, you may not be done checking in. You still will likely need to check in with Social Security personnel to let them know that you are there and ready and present for your disability hearing. The next thing I want to look at is important information that you should have at ready access when your disability hearing starts. And I've put a grid up on the screen, and I know this grid is fairly busy, but each of these data elements can bear a significant amount of influence over your disability case. And so it's important that you take note of these. I will tell you that it is wise to have a copy of your notice of hearing letter on your person at all times. it's also advisable to have a copy. And when I say a copy, we can be talking about a printed copy or a CD or an ERE if you're online of your entire case file. And I highly recommend reviewing that beforehand. If you have an attorney, they will likely have reviewed it exhaustively before appearing on your behalf. But if you're just by yourself, I highly recommend that you see and identify what all is in your case file, preferably not on the day before your hearing. It's also wise, if you have a VA disability rating, to bring a copy of that VA letter if it has not been entered as an exhibit already, as well as information about any prior filings that might have been denied by Social Security. Those aren't always easy to get your hands on unless you're in your disability file. But if you are in your disability file, it would be housed probably in Section A under Technical Issues, and it's worth noting. So really quickly, what I want to do is run through these items and just talk briefly about what each of them is. I'm not going to go into the significance of each of them, but I will tell you each of these items is of substantial importance and does play a role in the adjudication of a disability case. Though it may not garner a whole bunch of discussion at the hearing, having this information ready is a fairly easy task, and it pays off when called upon to speak to these specific issues. So, off to the right on this slide, I have also noted where you might find this information in the electronic file. And though I call it the electronic file, the ERE, the paper file still has sections as well, and so Section A can be found in paper files as well. So of course we're going to want the claimant's name, we're going to want their Social Security number, we're going to need the date of birth, and now we start getting into some more substantive issues. What type of application is this? And the reason why this is important is because the dates then that follow may have a significant, may require significant changes, or your burden of proof may be significantly changed based on whether it's a Title II or a Title 16. Title II, as you may recall, is a disability filing. Title 16 is an SSI filing. And we're not going to get too far in depth into the differences between the two, but suffice it to say that the nature of the application absolutely is affected by when the onset date is set, that's the alleged onset date, when the case was filed, because SSI claims cannot go back before the file date for retroactive benefits. And additionally, if you choose to revise your onset date, it may be wise to be in touch with the reasons why and have that enumerated, perhaps in a pre-hearing communication to the judge, but certainly in front of you as you appear at the hearing. It's also important to note the date of last insurance. Now, date last insured is important for disability cases only. This example that's in front of us is a Title 16 SSI case, so it's not of significant import for just an SSI case. But for disability cases, you need to know your date last insured, and you need to make sure that your alleged onset date falls before your date last insured. The additional items here below are the applicable listings. Those are Blue Book listings that enumerate what listings you believe that the evidence in your file supports. Grid rules. Grid rules are significant with regard to arguing how age, education, and past relevant work affect one's ability at certain exertional levels, how they affect one's ability to do other work. Additionally, having the highest level of education and training quickly at your fingertips, as well as a notation of any outstanding records. The outstanding records conversation has been changed somewhat due to the fact that there is a 5-day rule now whereby all records need to be supplied to Social Security more than 5 days prior to the hearing. If not supplied, they need to be identified with particularity to the judge more than 5 days prior to the hearing. If the judge is hearing about a new record for the first time at the hearing, there is no guarantee that the judge will allow the entry of those records when they are gathered. So that's kind of a gotcha there that you need to be aware of. So ensuring that your case file is complete is incumbent upon the claimant and is of significant importance. The last little block here that I've included is a notation about past relevant work. Past relevant work is work that has been done on a full-time basis for a long enough time to become acquainted with that work. And in this particular example, this person had 2 jobs. Past relevant work also is jobs that have been performed in 15 years prior to the adjudication of the case. So it's only the past 15 years from the hearing date that we're really focusing on. And in this particular case, there are 2 jobs. And what you see over there beside the jobs is information from the DOT. DOT stands for Dictionary of Occupational Titles. There will be testimony taken at the hearing, and I'm going to talk about it later, officially classifying these jobs, but it's never a bad idea to have some idea going into the hearing what likely the DOT code will be that is assigned, as well as the exertion required to do that job as it was performed and as it occurs in the national economy, as well as the SVP, which is an indication of the skill level. And the higher the SVP, the higher the skill. SVPs 1 and 2 are unskilled, 3 and 4 are semi-skilled, and above 4 are regarded as skilled. Again, there's a lot more to that topic with regard to transferability of skills, but we are not going to cover those in this video. I will say that this page, though it's dense with information, this page it refers to a number of websites. It comes to discuss a number of websites that are available to the general public online, and in fact, if you follow the web link at the bottom of the page, obflegal.com/helpful-disability-websites, you can find links to the Dictionary of Occupational Titles, links to the grid rules, links to the Blue Book for both adult and children. The Blue Book is the listings, the applicable listings, as well as other helpful information. So if you visit this website, it's a good jumping off point to get to a number of very helpful resources for folks that are preparing to go argue their disability case. So far we've covered what to do in advance and what information to read. The next portion of the discussion centers upon who will actually be in attendance at the hearing. This is not a public affair. Your case will not be heard in front of a group of people that are waiting to have their cases heard. This is a private affair, and typically there are only between 4 to 6 people involved in a hearing. Now, there are exceptions to this rule, but we're dealing in generalities here. So let's talk about who's going to be at the hearing. The first person is going to be an administrative law judge. Generally speaking, this judge will sit behind a traditional courtroom bench, and they typically will wear judicial robes. They do look like judges. They do sit behind benches. But this is kind of where the typical trappings of the courtroom end, in the sense that it is not a formal courtroom beyond this point. The judge will have an assistant, and the judge's assistant usually sits fairly close to the judge, typing notes and also running recording equipment. Now, when I say recording equipment, I'm talking about audio recordings. There are no video recordings made at hearings, which means that if you are discussing portions of your body, it's advisable to describe where on your body you're talking about as opposed to pointing. It's also advisable to use yes and no versus because, as you can hear, there may be a bit of ambiguity if you're only listening to a recording. There are no video recordings made of these hearings. So far we've got the judge and the judge's assistant. The next person in the room is a vocational expert. The vocational expert is going to participate in the hearing and is going to be one of the sworn witnesses. Their information that they typically provide is information about a claimant's past work, any transferable skills that might have come from skilled work that the claimant performed, and they're also going to provide response testimony to hypothetical claimants that are presented by the ALJ and potentially by the claimant. They're going to respond to those hypotheticals, indicating whether that hypothetical person can do the past work of the claimant or any other work. The next person is the claimant. The claimant is the person claiming benefits. Their role in the hearing is to answer questions about their past work, their impairments and the impact that their severe impairments have upon their life, their function, their family, and everything. We're going to get deeper into that in just a little bit. The claimant may have an attorney. Not every claimant chooses to be represented, but that will be the fifth person in the room. The claimant's attorney would facilitate testimony, facilitate communicating with the administrative law judge. They'd provide a brief in advance of the case, share a theory of the case with the judge, and make opening and closing remarks as allowed to do so. Again, the attorney is there as a facilitator and a communicator with the judge and with the vocational expert. And the purpose of the attorney is to speak the language of Social Security on behalf of claimants. Finally, and these are not present in every case, but claimants may sometimes call witnesses. Generally speaking, witnesses are presented at the leisure of the judge. Judges may decline to allow witnesses, but generally speaking, if a witness is required, the judge will allow them to do so. However, witnesses are not provided in every case, especially because character testimony is very rarely helpful. Where witness testimony is most helpful is where a claimant may not have insight into their condition or may not choose to provide insight into their condition. For example, a claimant who suffers from seizure disorder may well be unaware of how long their seizures last or how long their postictal periods are. Somebody that suffers from severe mental health issues may not have a sense of the scope of how their relationships are with others or what the impact of their mental health has upon those around them as well as any other individuals with whom they react as well as their daily function. Where a witness can add credible and informed testimony, witnesses are then sworn in and testimony from them is sought. As you can see here, at most, generally speaking, there are 6 people in the room. I will say every now and then a judge will call a medical expert, especially where medical evidence on a particular subject may be lean or not particularly well expressed. That's fairly uncommon. But the bottom line is, even with the witness, the most people involved in a disability hearing are going to be about 7, with the most common number being somewhere around 4 to 5. This is a very childish depiction of what the hearing room looks like. This is a top-down view, but this is generally what claimants can expect when walking into a hearing room. And when I drew this 2 different ways because sometimes hearings are held over video. Generally speaking, I recommend that claimants object to video hearings for a variety of reasons. However, with that said, many folks choose to have their cases heard over video, and this room accommodates that. And so what I would suggest to you is just looking from left to right. You can see the judge kind of sitting in the center of a bench with a couple of computer monitors in front of him as well as a microphone. Offset to his side is his assistant, who's, like I said, going to be typing notes and running these microphones. The claimant sits all the way opposite the judge, basically looking at the judge. And then to the claimant's side is their attorney as well as the vocational expert. Witnesses are either sequestered, which means kept out of the hearing room until they're called to testify, or they sit off to the side until called to testify. I put the large screen TV behind the claimant because what will happen is, in the case of video hearings, everybody will basically sit in the same spot except for the administrative law judge, and the administrative law judge will appear on the video screen, which also has a camera on it. And so all talking will be done through Skype-like technology through a video screen. So what happens during the hearing? Well, several things. The hearing's going to last probably about 45 minutes, although they go longer sometimes, and every now and then they're shorter as well. But generally speaking, it's good to count on 45 minutes to an hour for a hearing. The first thing that's going to happen is when you walk in the door, the administrative law judge is going to offer a greeting. He's going to introduce everybody in the room, going to offer to recite the issues, which that may be waived, and especially if there's a claimant's attorney is present, hearing the issues again is probably going to be something that just eats up time. And if there's a lot of testimony to be taken, waiving a recital of the issues can be helpful as it saves a few moments. Additionally, the judge is going to talk about admitting the evidence and admit it. but the discussion of it will include the 5-day rule and potentially will indicate whether they're going to keep the record open for additional records that might not be available as of the date of the hearing. At this time, the judge may also choose to discuss procedural issues, such as amending an onset date or identifying that a closed period is being argued. Generally, just anything that might go off the standard beaten path of a disability hearing might be addressed at the front end. And then finally, the judge will swear in witnesses, and the people in the room that will testify are going to be sworn in. And so that's going to be the claimant and the vocational expert, and if there is a medical expert offering testimony, they will be sworn in too. Nobody else gets sworn in, not claimant's counsel, not the assistant, nobody else, just the claimant and the experts get sworn in. That whole process takes about 5 minutes or so, and from that process, we move forward into a conversation with the claimant. This is the single biggest portion of the disability hearing, is this conversation with the claimant. And in this conversation, the conversation is likely to include a discussion of the past work, and that would include job responsibilities and why work ended, why new work was sought, any accommodations that might have occurred during the work, circumstances around the work. That will take a few of those moments, but most of where the time is going to be spent is discussing the person's impairments. What are the most severe issues that they're dealing with, and how do those issues affect activities of daily living and their function? Okay, I always recommend starting with the most severe impairments first, and in fact, judges, if they're running the questioning themselves, will often say, what are the most severe issues that you're dealing with? Start with the most severe first and tell me about it. During the conversation, if a witness is called, that witness will be sworn in later, and then discussion will be held with the witness during that time period. And what I would say is claimants need to be prepared to either have the conversation with the judge directly. If they have an attorney and the attorney is told to do so by the judge, the conversation may primarily be between the claimant's attorney and the claimant. Or it may be kind of a three-way conversation between the claimant's attorney, the claimant, and the judge. And that's really what it most frequently looks like, is the judge filling in additional gaps should the claimant's attorney and claimant not hit on a topic that's of particular interest. But the bottom line is it's a very casual conversation with the claimant about what the claimant's dealing with. And I think the most important thing that in preparing for a hearing that a claimant can do is identify the health issues that affect them the most and clearly identify how those issues affect their daily lives. And that's function. I mean, how does it affect the ability to sit, the ability to stand, the ability to walk, the ability to reach, bend, so on and so forth. That sort of testimony is very, very helpful, and I would say that for claimants that are preparing to go to court for a disability hearing, it is much more useful for them to be an expert on themselves. A U expert is what I refer to it as opposed to a medical expert who knows all of the medical terminology and all of the specific medical issues. Knowing what those issues affect is, in my experience, is of more probative and helpful value when preparing for a hearing. So after the conversation with the claimant, and that I say it lasts 25 minutes. This can go for longer, and it often does, but 25 minutes is probably a good average to look at. The next conversation that happens is a conversation with a vocational expert. And that typically lasts about 10 minutes. And what happens during this conversation is the vocational expert will use their expertise to classify a claimant's past relevant work. You'll remember that you may have already done that in preparing for the hearing, but they are the quote-unquote expert who is going to do so now, and you'll be able to check your answers and see where there might be disconnects and see if further examination might be warranted on that subject. Additionally, if there's a history of skilled work, the vocational expert will identify transferable skills as a portion of their testimony, and then they're also going to respond to hypothetical claimants and identifications of jobs that those hypothetical claimants might be able to perform. And a hypothetical claimant is going to be presented usually first by the judge, and then the hypothetical claimant may be altered as needed by the claimant's attorney or the claimant themselves to what they feel better reflect the state of the real claimant. But a hypothetical claimant question may sound something like, Madam VE, please assume a hypothetical claimant of this claimant's age, education, and past relevant work. I want you to further assume that they're limited to light work. They require the ability to sit and stand in increments not to exceed 30 minutes, and only can occasionally reach with their right upper extremity. Given those limitations, is there any work that this hypothetical claimant can perform, either past relevant work or other jobs? And again, judges are going to ask those questions on a more targeted basis to better target the issues that individual claimants in front of them are arguing. However, they're going to sound roughly like that, and they're designed to solicit testimony that adds insight with regard to how certain ailments affect claimants' abilities to work. I will also say that it's not uncommon for a judge to ask 3 or 4, even more hypotheticals. And what they're doing in so doing, generally speaking, is level setting. So they may introduce a very unfavorable hypothetical and then work their way slowly over to the very favorable hypothetical. So it's wise to listen to these, write these down as they're being taken, and understand the changes between them so that modifications may be made judiciously that result in a favorable testimony from the vocational expert. So after the piece of the vocational expert is done, then there's basically tying up loose ends, conclusory remarks, and then conclusory remarks and a dismissal. That'll take about 5 minutes. And there might be closing arguments to be made. There might be last-minute procedural items to be discussed. But generally speaking, it's just kind of a catch-all time where is there anything that has not been discussed that needs to be? And then the judge will often talk about when their decision is going to be mailed. In my experience, typically speaking, these days, 2018, we're looking at about 8 to 12 weeks after the hearing before receiving a decision in the mail. But as you can see, if you add all those times up, those all add up to about 45 minutes. And I'd say that on average, 45 minutes to an hour is a pretty good time period to expect one's disability hearing to last. I believe that a discussion of disability hearings probably is incomplete without enumerating some tough topics. And when I say tough topics, these don't necessarily apply to everybody. But if these apply to you in your case, I strongly recommend thinking about them before you walk into your hearing, in the sense that these can be ambush questions if you're not careful, and if you don't have a satisfactory answer, in my opinion, they can cause a material effect to your case. So I would highly recommend that you take inventory. And this is not an exhaustive list of tough topics, but it's one that in my experience I've seen definitely leave their fingerprints on cases, and not necessarily in a good way if you don't have a good explanation. So without further ado, let's dive into these. The first tough topic, failure to seek regular care for a severe impairment. If somebody is arguing that they suffer with 10 out of 10 pain every day and they are barely able to walk or move, the fact that they've not had medical care for that issue for a year and a half could be very troubling for a judge. And so there ought to be a really good explanation for why there has been no care. And that sort of testimony is likely going to be the thing, if it's convincing, that saves the case, because a long stretch without regular care is problematic, especially if there's a local health department where one could get maintenance care, or if there are local free or reduced cost or sliding scale clinics that are available to the individual and they just didn't seek care there, as opposed to folks that might live in an area where getting regular care is more of a challenge. Again, just be ready to hear about this, because it's very, very difficult to establish disability without regular care for the issue that causes you to claim disability. Kind of walking hand in hand with this are physician indications that a claimant was non-compliant. Now, non-compliance takes a variety of forms. If a claimant is non-compliant because they did not have a specialist through which they could seek specialty care, that's generally speaking a little bit less troubling than a client who had the ability to get medication filled and chose not to do so even though the medication was nearly free. Noncompliance takes a variety of forms, but if your physician indicates that you're noncompliant, what it indicates is that perhaps they might have an expectation that you would get better, but for your behavior preventing you from getting better. And you do not want the judge to assume the worst about noncompliance with physician orders. And again, if a physician is ordering you to do something that you have religious or other grounds to object to, that certainly needs to be noted either in your medical files or as a portion of your testimony. And so, again, it's acceptable to be non-compliant in certain cases, but just be aware of the assumption that can be made when somebody reading your medical records sees non-compliance. The use of alcohol or illegal substances. This is a biggie, especially for cases where there's a mental health component. If somebody is claiming disability based on mental health reasons, the use of alcohol or illegal substances can hijack a case immediately. Basically, if the judge chooses to do so, if the judge sees the use of alcohol or illegal substances as a factor which causes the person's condition to be disabling, and but for the use of those substances the person would not be disabled, that's a quick way to lose a case. On the other hand, I will say that illegal substances aren't necessarily the kiss of death to every case. For example, if somebody is dealing with cancer pain or neuropathic pain as a result of radiation treatment, and they might be utilizing a substance like marijuana, that's a little bit more explainable, and it is not at the heart of their disability. Somebody claiming cancer is claiming a physical ailment with nerve pain. That is, while it could still create issues depending on the judge and how they feel about that particular substance, what I will say is there are varying degrees of damaging, with illegal substances and alcohol use being probably most damaging to folks that are dealing with either mental issues or issues that are caused directly by the use of those substances, like a cirrhotic liver. This is another gotcha. The claimant's doing fine. I very frequently see this in medical records, and it's important to note that doing fine can mean a whole variety of things. And if your physician indicates that you're doing fine, make sure that they further indicate exactly what's going on with you in your medical records, or if they don't do that in your medical records, make sure that you're ready to explain that fine for you may mean something different than fine for anybody else, and offer testimony about that. Doing fine is a very non-specific relative term, and for somebody that's been, for example, bedbound, the ability that they might be able to take 20 or 30 steps outside of their bed would be an indication that they're doing fine, that they're improving, that they're getting better. But at the same time, 20 to 30 steps outside of a bed doth not a healthy person make. And so it's really important that throwaway sentences like that be identified and properly explained if possible. The next bullet point is work being performed during the period of disability. It's not impossible to work and claim disability, but you need to be very careful about how much money you make and how much work you do, and prepare to answer questions about, well, if you're working this much, why can't you work full time? Be ready to discuss that. Be ready to discuss any accommodations that the work that you're doing might allow you. It's really very important that if you have worked during the period of disability, that you be ready to navigate that. And you know, if you found that you have worked too much during your period of disability, that's still not the kiss of death to your entire case, but you need to start considering making arguments along the lines of an unsuccessful work attempt or other issues that I'm not going to fully develop in this video. Walking hand in hand with work performed is money earned during the claimed period of disability. It's not uncommon for folks that have owned their own businesses and handed off the operation to somebody else to have unearned income. It's very important that you identify that income as unearned income, or as income that's being paid for doing no work, or anything along those lines. You do not want it to be assumed that you are working, especially above SGA levels, that's substantial gainful activity levels, during your period of disability. Also, sometimes disability policies pay out under the company's tax ID from which the person went out on disability. It's important to identify the date and have any additional documentation in support of claiming that that was disability payments as opposed to payments for work. Again, this is one of those things that can be a real gotcha even though the claimant, has done nothing wrong. It's something you need to be aware of, though, and be ready to speak about. Finally, it's important to note that it is not uncommon to be asked at your disability hearing who you live with, how old they are, what you're doing for them on their behalf. This is a very common gotcha, especially for single parents that are disabled. If they're caring for young children, it's very, very easy for a judge to assume or imply that if they're capable of caring for an individual at home, then they must be capable of doing work. Again, you always need to be truthful when offering testimony, but it's important to note that if you are caring for a family member, or if you leave your home, your family home, to go to a parent's home to stay with them for an extended period, and you're helping them in and out of their bed or driving them around to medical appointments or those sorts of things, just be aware that you are going to probably be called upon to talk about this, and be aware of the impact that it can have on the appearance of disability. And again, simply because you are caring for a family member does not bear truly on your whether you're disabled or not, but make sure that you explain the issues and the hardships that offering that care might cause you. Don't just let it hang that you are caring for family members. Talk about the particulars and the challenges that present themselves to you as you offer that care. Now, a few words of general advice for claimants as they approach their disability hearings. Always tell the warts and all truth. And what I mean is the truth is not optional, but a lot of times when talking with friends and family, if somebody asks how you're doing, you might be inclined to say, well, I'm doing all right. And you know what? That's socially acceptable, but in the terms of disability, that is not going to help you out at all. Talk about the challenges that you deal with. Talk about the issues that present themselves, and talk about all of the truthful items that cause them, that rear their ugly heads on an average day that affect your ability to function as an employee, as a human being, and otherwise. Walking hand in hand with that, be a you expert, not a medical expert. Testimony, in my opinion, is best when it expresses the limitations that a claimant experiences. Having them know all the medical terminology can be very helpful in certain cases, but in most cases, having them be an expert on their limitations and how those limitations express themselves is of the greatest import. Not knowing the official name or the official vertebrae location of a back issue is, to me, not nearly as important as knowing that their back prevents them from sitting for any length of time, standing any length of time, bending, limits the amount of weight that's able to be lifted. All those sorts of issues. Being an expert on the impact of the health issue on the body, as opposed to being an expert on the health issue itself, I think is a significant aid to claimants as they prepare themselves to go into a hearing. Finally, when discussing past work, make sure you share the job exactly as it was performed. It's not a job interview. And folks, when they're talking about their past work, especially work that they're proud of, often have a tendency, I've seen, to engage in puffery, treating it as if it were a job interview and trying to make sure that they're as impressive as possible. And that does make a lot of sense when seeking another job, but in this case, it is best simply to share exactly what was done on the job during past relevant work. Folks always ask me what to wear to the hearing. Generally speaking, I advise comfortable clothing. I generally also advise a shirt with buttons, a collar with buttons if possible, but wear comfortable clothing. Wear clothing that's not going to distract from the testimony that you're going to offer. So it's important to be comfortable. Speaking of comfort, if you're in the hearing and if you happen to be becoming uncomfortable due to a physical issue that you're dealing with and you need to stand up or stretch, generally speaking, most judges tend to be very, very accommodating and will allow you to do so, as long as you can still speak loud enough to speak into the microphone that's recording the proceedings. So you don't need to suffer in silence. I would also advise folks not to put on a proverbial show. Don't bring assistive devices, that's canes or braces or anything, that were not approved by your doctor. That's not going to do you any favors, and very frequently the actual assistive device gets talked about, and if you cannot truthfully testify that that's a prescribed or doctor recommended item, it can often hurt credibility. So I would advise being very judicious with that. Finally, well, maybe not finally, but we're almost there. Seeking supportive letters from your treating physicians is of the utmost importance. If your doctors will support your cause, it is absolutely worthwhile to seek medical source statements, psychiatric review technique forms, or just supportive letters from them indicating what your limitations are, what your treating relationship has been like, and the journey that they've seen you take. It's really helpful if you can seek these, and I recommend that everybody do so. Ideally multiple times throughout the course of a disability application, but certainly there right before the hearing, it's kind of a very helpful thing to have a capstone there with the information from the treating physician. I would also recommend that you take a look at the judge that you've been assigned. Take a look at their statistics. While statistics don't necessarily tell the story for every individual case, it's worth knowing the stats behind the individual that you're arguing in front of. That website that I cited earlier, you can link. There's a link to an administrative law judge statistics page. So if you visit that page, you'll be able to pull administrative law judge as well as office-wide and nationwide statistics if you so desire. Finally, and I spoke a little bit about this previously, but during the vocational expert testimony, it's best not to react to unfavorable testimony or unfavorable hypotheticals. Rather than reacting, simply adjust them when you have the opportunity to examine the vocational expert. Adjust them with facts that are supported by the medical record that bear unfavorably on your ability to work, and you'll have a much better result than simply getting upset about the VE testimony. Well, that about does it for this video. What to expect at your disability hearing. I'm Thomas O'Brien. I thank you for your attention and the opportunity to share this information with you. And I'd like you to know that if you do need help with your disability case, or if a loved one needs help, I'm available. I work throughout the state of Georgia. If you're outside of the state of Georgia, thank you for watching, and if I can help you find an attorney that's local to you, I'd be happy to do so. I will say, having a good, solid local counsel makes an awful lot of difference in the disability process, and I would recommend everybody that's contemplating a hearing retain local counsel that's local to them and that specializes in this field of law. Thank you very much.